Without further ado, my friend Souder Tate.
Can you see me?
I see
Hello?
your screen. Yep. Can you hear me, Souder?
I can.
Excellent. What I can see right now is your screen.
How about that?
There you go. That's
All righty.
great. I'm
Well,
going to
thank
get out of your
you.
way.
Thank you very much. That was quite an introduction. I appreciate that very much, Matt. I really do. This is really one of my favorite subjects. And I really appreciate you all coming and listening to me today. In the 1800s, someone wrote the following words of wisdom. Sow a thought and you reap an action. Sow an action and you reap a habit. Sow a habit and you reap a character. Sow a character and you reap a destiny. These words seem appropriate today as we look at offender behavior and how Missouri is embracing an evidence-based approach to sentencing and supervision. As defense attorneys, we represent clients every week whose thoughts, actions, and habits have resulted in criminal charges, whether they are guilty or not. The criminal justice system is in the behavior judging and the behavior modifying business. From the moment charges are filed, behavior is controlled and directed through bond conditions and pretrial release. And if our client is found guilty, the court retains jurisdiction to modify their behavior further. Incarceration is one of the options to control and modify behavior, but it costs a lot of money. And research shows it really does not have a deterring effect. In fact, some research shows that it can be criminogenic. That means it can actually cause future criminal behavior. Supervision of offenders on probation or parole is clearly about behavior modification. And the risk-need responsivity model of offender management is currently the most widely adopted model for offender management and behavior modification in criminal justice populations. The RNR model focuses on identifying and addressing certain criminogenic risk factors in order to reduce the risk to reoffend and to reduce the amount of public funds which are being spent incarcerating offenders. Now, imagine going to the doctor and being told you're extremely sick. There are two treatment options. Option A is a pill which costs $500, is easy to swallow, and has about a 25 to 35% survival rate over 5 years. Option B is a shot which costs $100, is relatively painful, but has a 65 to 75% survival rate over 5 years. Which do you choose? Well, see, these are essentially the options which are being offered between the traditional way of addressing offender behavior and the risk-need responsivity model. Missouri has adopted two public risk assessment tools based on the risk-need responsivity model. Our courts began using the risk and needs triage, also called the RANT, around 2012. In 2018, our legislature enacted Section 217361, which required the Department of Corrections to adopt an evidence-based public risk assessment to use with all offenders. And on June 1st, 2019, the Department of Corrections implemented the Ohio Risk Assessment System department-wide. My goal today is to explain the basic principles of the risk-need responsivity model of offender management, as well as the theory supporting it. I then want to explain how Missouri has implemented this model through the RANT and through the ORAS. I will discuss how criminogenic risk factors from the Ohio Risk Assessment System are being reported on sentencing assessment reports, and I want to give you some ideas on how you can use these principles in your own practices. Now, this is a good place to ask an important question. Why should you listen to me? What is my authority? Well, I've been an attorney for almost 35 years, but it wasn't until about 11 years when I began volunteering on local drug courts that I really was introduced to evidence-based sentencing. In fact, I think I attended my first drug court conference in 2010, and by 2011, I had drunk the treatment court Kool-Aid. From 2015 through 2018, I helped train drug courts in several states for the National Drug Court Institute. In October of 2018, I was trained and certified on the level of service case management inventory, which is an evidence-based public risk assessment comparable to the ORAS. Last year, I was certified on the RANT, and I plan on getting the certification on the ORAS in August. It was originally scheduled for earlier this month. Now, having said that, the internet is a marvelous tool. And if you type in the right string of words, it can grant you access to other marvelous tools like the Ohio Risk Assessment scoring guides. So my discussion today of the ORAS is primarily based on the language I have seen so far in sentencing assessment reports, from the scoring guide, and from scholarly articles I've read online, and also from the understanding of risk, need, and responsivity principles I've gained from working with treatment courts and being trained on the LSCMI. So with this in mind, my primary goal is going to be to show you how to help your clients get better dispositions in their criminal cases by understanding and applying the risk, need, responsivity of offender management. Not every client's going to have a chance at probation. And although some criminogenic risks can be addressed in prison, the R&R model is designed for use in community supervision. The goal is to identify moderate to high-risk individuals and to match them with the appropriate services in the community. Why? Because research continues to show that this approach actually reduces future criminal behavior while reducing public spending. So how do we know this is the best option? I have found, or when do we know this is the best option? I found putting this in terms of a general sentencing theory is helpful because it gives me a structure for my sentencing argument. It can also serve as a checklist or workflow for evaluating and explaining to my clients the probable outcome in a criminal case. So my sentencing theory is 1 part federal sentencing statute and probably about 4 parts of what I've learned through treatment courts. And here it is. Unless there is a mandatory minimum sentence, or unless the nature and circumstances of the offense or the history and characteristics of the offender mandate incarceration, the goal at sentencing should always be rehabilitation in the community using the R&R model of offender management to address those dynamic criminogenic risks. Now, research has consistently shown that there are 8 factors which are primarily responsible for future criminal behavior. Those factors are known as the central 8 criminogenic risk factors, and they are further divided into the big 4 factors and the moderate 4 factors. And the big 4 factors are believed to be more strongly associated with recidivism than the moderate 4. And in fact, research has been clear that no factor more strongly predicts future criminal behavior than prior criminal or antisocial behavior. The big 4 criminogenic risk factors are history of antisocial behavior, antisocial personality pattern, antisocial cognition, also known as criminal thinking, and antisocial associates. We see the word antisocial repeated in each factor, so we need a definition. In a nutshell, antisocial behavior disregards the rights of others and violates social norms or laws, while prosocial behavior benefits other people and conforms to social norms and laws. The moderate 4 criminogenic factors are education, employment, family and marital problems, lack of prosocial or leisure recreation activities in your life, and substance abuse. Now, it's interesting to note that substance abuse is considered to be a moderate 4, not one of the big 4, but it's also considered to be an intrinsic criminogenic risk factor, meaning it tends to affect all other risk factors. The other thing is there are 2 types of risk factors. There are static risk factors. These are unchanging conditions that really are not amenable to treatment interventions. Then we also have dynamic risk factors, which are conditions that change over time and are amenable to treatment interventions. The goal of the R&R model of offender management is to reduce an offender's overall risk to reoffend by identifying and targeting dynamic, changeable criminogenic risks, and also identifying the barriers which can negatively affect an offender's ability to respond to those interventions. And it's based on 3 core principles: the risk principle, the need principle, and the responsivity principle. In the risk principle, the intensity of the interventions we do should match an offender's risk of reoffending. If you're higher risk, you need to do more intense interventions. The need principle says that intervention should target an offender's changeable needs, such as antisocial behavior, substance abuse, antisocial peers, etc. Now, the word need, that is just how some fancy people like to refer to a dynamic criminogenic risk, but that's what a need is. Finally, the responsivity principle. Intervention should take into consideration the general and individual factors which can affect an offender's ability to respond to intervention and treatment. So the risk principle is telling us who we should target. The need principle is telling us what we should target. And the responsivity principle tells us how we should target, both in general terms and then specific to each offender. So as the model goes and as the research shows, following these general principles and evidence-based best practices based on these principles will reduce recidivism rates. So there are also 2 types of responsivity. General responsivity. This means you use cognitive social learning strategies to influence behavior because they are the most effective. And this is regardless of what type of offender or offense. Examples would be pro-social modeling, appropriate use of reward and sanction, and helping them learn problem solving. While specific responsivity fine-tunes the cognitive behavioral intervention by considering an offender's strengths, their learning style, personality, motivation, and then such barriers as mental health, trauma, physical addiction, housing, and transportation.
Souder, if I may, we do
Yes.
have a question that came in through the chat that I think might fit in well here.
Sure.
The question is, where are SAR writers looking at when looking at risk factors, i.e. uncharged contact, example, sex offender, and now other victims from over 20 years are coming forward?
Whoops, hold on a second. Let me go back. My understanding, what I've seen lately in the sentencing assessment reports that I'm getting, I actually have seen some language that it's all self-report. I'm going to talk about this a little bit later, that when they're doing the ORAS and when specifically they're doing the community supervision tool, that's the flavor, that's the tool in the Ohio risk assessment system that we're going to be seeing. That it looks like for the sentencing assessment report, it is primarily based upon self-report. Although if you do a full ORAS, it talks that there are basically other areas that you look, looking at the file, collateral information, where they're coming up with the information. But that's my understanding where they're getting it. It's during the interview and self-report with the offender. Let's see, did that answer the question?
think it did. Are you on slide 6 right now? Is that what your screen is showing? Where?
Oh, let's find here. I think it says two types of response. Let's see. Two types of responsivity. That's where we're getting ready to start.
Two types of risk factors. Static risk factors is what's up on the screen right now.
Oh, okay. Hold on again. So you're showing two types of risk factors. Here we go. Is that what you're seeing?
Yeah, we're seeing two types of risk factors, static risk factors,
Okay.
unchanging. Yes.
Okay, so then the other one are dynamic risk factors. And then we've done that. Two types of responsivity. So the first type, again, uses cognitive social learning strategies to influence behavior. Specific responsivity fine-tunes cognitive behavioral interventions by considering strengths and then the barriers such as mental health, trauma, physical addiction, housing, and transportation.
You might want to refresh your screen, Souder. I think it might be frozen.
Okay.
Hey, technology is wonderful when it works.
It is, and I don't know why it's not. So let's see here. Is it showing up now?
My screen still shows the same. Two types of risk factors, static risk factors.
So I'll tell you what, let me do. Let me see if I can give you back over control for a second.
Sure.
Or can you take it back?
Oh, probably.
Oh, wait. I found it.
Ah, there you go.
Never mind.
Good work.
Never mind. I know how to do a PowerPoint. I don't know how to do this slideshow software. Let me go back. There we go. Two types of responsivity.
Thank you, sir.
Is it back? Two types of responsivity.
Yep. Go for it.
Okay. Specific responsivity. Here we go. I was going to tell you that there are two types in addition to two types of responsivity. There are two types of behavior we need to talk about, and those are proximal and distal behavior. My definition of proximal behavior is behavior for which I am responsible and which I have the present capacity using reasonable effort to perform. Distal behavior is behavior I may be responsible for, but which I do not have the present capacity to perform. I'm putting this in here because you see this a lot in treatment courts and probation violation. I mean, here's an example. Jenny is just starting drug court. She's continued to test positive for opioids for the first few weeks. She's a long-term heroin user with diagnoses of substance abuse disorder, bipolar rapid cycling, and PTSD. Now, the judge has three ways that he can respond to Jenny's behavior: with a reward, a sanction, a treatment response, or really with any combination. This is why determining proximal versus distal behavior is important. You don't want to put Jenny in jail. Based on this information, her continued drug use is distal behavior, meaning that although she is responsible for her drug use, she does not have the present capacity to stop. Therefore, the response should focus on treatment. If, however, the violations were that Jenny repeatedly failed to report to her probation officer or for UAs or to court appearances, that behavior would be proximal behavior and the judge should respond accordingly. One of the reasons I bring this up is that if you look at proximal and distal behavior, I think what you're seeing it reflected in these responsivity issues that we're going to be talking about. So let's talk a little bit about how the risk need responsivity model works. In a nutshell, you assess, you intervene, you monitor, and you reassess. You're identifying criminogenic risk factors, and you're identifying any specific responsivity factors, and you're using evidence-based public risk tools and clinical assessments. The risk to recidivate is generally determined by looking at the sum of the risks found in the central 8 risk domains. Now, you're going to see different assessments do it a little bit differently, but this is kind of a general rule. So criminal history is considered a static domain, while the other domains are generally dynamic. What that means is that the factors in your criminal history domain, you can't change them for the better. That's what prosecutors like to talk about, but that's not what we need to be talking about. We need to be talking about what can be changed. So once you have determined the dynamic criminogenic risks and the specific responsivity factors, you address those first. And you also address alcohol and drug use if they have a moderate to severe substance use disorder than the other criminogenic needs. You use evidence-based principles in responding to offender behavior, for example, incentives, sanctions, and treatment responses. And then you can reassess at a minimum of 6 months or if there's a critical incident. I took the critical incident language from the Ohio Risk Assessment System community supervision tool. A critical incident would be something such as a new laws violation. I also included a slide on the order of interventions. This is from the Substance Abuse and Mental Health Services Administration Gaines Institute. So I'm going to let everybody that wants one. I have a copy of the full presentation with full-size slides that has speaker notes with it. So if anybody wants this, I will email it to them after the presentation, and there should be a copy available. There should be information and a link down there on where to find this information on the order of inventions. So here's where this is important to us. If you have a client who continues to use or otherwise violate the terms of their probation, it most likely is going to be because no one ever addressed certain specific responsivity issues, which are required in order for them to respond to the criminogenic interventions. For example, if they're not responding to addiction treatment, they're hanging around the same old people, it's most likely because they have mental health issues or a problem such as physical addiction, housing, transportation. After you do stabilization and criminogenic, you do maintenance. You deal with education, etc. And then you deal with the remaining needs. And again, there's going to be a link on here for you to access this. I also included this. We're not going to really go over it except for the 7 dynamic criminogenic needs. These set out the factor, the indicators, and the intervention goals. And this kind of gives you a ready-made way of saying, what should I be working on when my clients exhibit one of these need factors? One last thing, you see there the level of service case management inventory. That is the full-blown public risk assessment I've actually received training and certification on. I'm going to mention it a few times later in the presentation, but what I want you to see is the way that the LSCMI is set out exactly matches up the central 8 criminogenic risk factors. The reason for that is the people who designed this tool also came up with the central 8. So now we're going to start talking about the risk and needs triage. I have had certification on this, although I'm going to tell you they are as secretive as can be on what all this stuff means. But here's what I know. First of all, there are 51 questions. The first 19 questions can be completed in less than 15 minutes. And what these 19 questions are doing is they are identifying criminogenic needs and separate prognostic risks. Unlike you'll see in the Ohio risk assessment system, where the overall risk to reoffend is the total of the domains, that's not the way the RANT does it. So, and I'll show you in a little bit exactly what we're looking for, but the three needs we're looking for are substance use disorder, chronic substance use related medical condition, and mental illness. The RANT, the final 42 questions of the RANT screen are to determine if you have or likely have an antisocial personality disorder. Criminogenic needs are going to be discussed in slide 17, and then we're going to talk about the prognostic risks in slide 19. Now, that is what, when you receive a RANT report, let's say from treatment court, that's what it looks like. And look at the bottom, that's the most important thing. The target population for adult treatment courts is high risk, high needs. And there is a lot of evidence showing that if you mix up these levels, like you put high risk, high needs with low risk, high needs, you're going to make people worse. You're going to make the people who are low risk or low needs high risk or high needs. So we try to avoid that. Now, the first of the actual needs that is shown is physical addiction to drugs or alcohol. And this is noted by cravings and withdrawals. And this is a subset of the symptoms found in the DSM-5 definition of a substance use disorder. The next need is a major mental illness, such as major depressive disorder, bipolar, schizophrenia, or PTSD. Finally, they identify the chronic substance-related medical conditions as a need. That could include hepatitis C, HIV, high blood pressure, if those are a result of substance use. Now, the DSM-5 came out in 2013 to replace the DSM-4. The DSM-4 identifies a substance use disorder is defined as having two or more symptoms in the past year resulting in distress or impairment. And the diagnosis is made separately for each substance, and the severity of the substance use disorder is determined by the number of symptoms. 2 to 3 is mild, 4 to 5 is moderate, 6 or more is severe. Here are the 11 symptoms according to the DSM-5. That in the last 12 months, you've used larger amounts of drugs, used it larger for a longer period of time. You've tried to control or cut down, but were unable to do it. You spent a lot of time getting, using, or recovering from using drugs. Strong desire or urge to use drugs. Got so high or sick from drugs that you couldn't go to work, go to school, care for children. You continued using drugs when it led to social or personal problems, spent less time at work, school, or with friends, used drugs in a way that put you or others in danger, and that you needed to increase the amount of a drug you were taking so that you could get the same effects or results before, or using the same amount, basically tolerance, and then finally is withdrawal. Now, if an individual previously had a substance use disorder, but has had no symptoms in the previous 12 months other than cravings, that substance use disorder is considered to be in sustained remission. Here are the prognostic risks we were going to talk about. Prior felony or serious misdemeanor conviction, age of onset of using drugs, criminal activity, deviant peer affiliation, if you actually have a diagnosis for an antisocial personality disorder, and you can read the rest. Now, where I got these is I went and looked at rants that I have actually observed through treatment court, and these appear to be the 11 risks that I have seen. Probably the one that I have seen the less, honestly, is prior failure to appear. So now we're going to talk a little bit about the Ohio Risk Assessment System. So the Ohio Risk Assessment System actually consists of 10 instruments. Originally, there were like 5, and these other 5 have been added since then, and most of these have to do either with prison or with misdemeanor assessments. The development of the Ohio Risk Assessment System began in 2006. It became operational in Ohio in 2011. These tools can be used at pretrial, prior to or while on community supervision, prison intake, or at reentry. And although there are now 10 instruments in this system, the one tool that we're most likely to see as criminal defense attorneys is the community supervision tool, right there, which is being used when preparing sentencing assessment reports and with offenders who are being placed on probation. The ORAS community supervision tool contains 7 domains: criminal history, education, employment, finances. You can read down through them there. This last one, criminal attitudes and behavior problems, is pretty much a blending of 2. Now, on the ORAS, there are a total of 35 items, including a total of 49 total risk factors. 18 of those factors, by my count, cannot be changed. 31 are dynamic factors and can be changed. There are 4 parts of a community service tool interview. We talked earlier about the self-report, and I believe that's what they are using for the CST information placed in the sentencing assessment report. The other 3 ways, though, are an interview guide, which is used as structure for a face-to-face interview, file review, and then review of collateral information, either that the offender brings or that other people may provide. So the way that the ORAS builds itself is it's an assessment-driven case management, and its purpose is match offender to services and programs which address risk factors and remove or accommodate any barriers related to those responsivity considerations. So with the Ohio Risk Assessment System community supervision tool, the probation officer is going to assess risk, prioritize needs to target, develop goals and objectives based on the individual needs which have been identified, identify and address the barriers. You do an ongoing tracking of progress and reassess as necessary. So I've given you a series of pages which set out these 7 domains. On each of them, I'm telling you the total number of risk factors, which are static, which are dynamic. If they are static and you cannot change them, they will be in red. The reason for this is a tool for you to look at when you're reading the Ohio Risk Assessment System results. And you will know pretty much immediately which factors can be changed and which factors cannot. Now, this is important. I spoke with a probation officer 2 days ago about a question I have. As you can see, the second thing is number of prior adult felony convictions. According to this probation officer, and they are at a supervisory level, suspended impositions of sentence are not considered a conviction on the community supervision tool. However, a prior SIS probation does count as a prior sentence to probation as an adult. I think I said this earlier. Prosecutors like to focus on sentencing on factors which cannot be changed. We need to make sure we're focusing on factors which can be changed, and specifically those factors which can only be changed if our client remains in the community. Okay, so with education, employment, and financial situation, those first three are static. And as I said, less than a high school or GED. If you have a GED, it's still a risk factor. Have you ever been suspended? Were you employed at the time of the arrest? None of those can be changed. But whether you are currently unemployed, you currently make better use of time, or your financial situation is poor, those are factors which you can address, which you can reduce the risk factor on. So I also gave a copy of the education employment to show you how it is done on the LSCMI. Now, if you remember, three static, three dynamic risk factors under the ORAS. This is one of the reasons that you can't teach to the test. You can't try just to address these specific risk factors. So here on education employment on the LSCMI, the only static risk factor is, have you been expelled, suspended, or received in-school suspension at least once? So where being currently unemployed or frequently unemployed, or even better, less than a regular grade 12 or equivalent, that may not help you on the ORAS, but I'm telling you, it reduces their risk to reoffend. So you need to look at these terms and not as just striking off the risks that we can address, but look at the big picture. How can I help my client deal with education and employment deficits?
Souder, we have a question. Do you have just a second to take the question?
Sure.
Excellent. Craig, I'm going to unmute you. I'm going to try to. You got yourself muted. Craig, if you unmute yourself, you can ask your maybe your hand went down. Sorry to interrupt, Souder.
Okay, that's fine. So family and support, there's only one static risk factor, and this is actually a risk factor on
Souder, are you there?
Yeah, can you hear me?
Yep, I can hear you.
Okay, so back to family and social support. Parents have a criminal record. One parent having a criminal record, that is a static risk factor. And it's actually a static risk factor on the LSCMI. But the rest of these risk factors, currently not satisfied with marital or equivalent situation, no support, not satisfied, an unstable resident, these are all things which are dynamic because they can be addressed through an intervention. Let's see. Neighborhood problems. I clicked by that real fast. High crime area, drugs are readily available in the neighborhood. Funny thing about that, those aren't found in the central aid, but they are mentioned here, and they are dynamic. High crime area is one risk factor. Drugs readily available in the neighborhood. You'll see some of these where, depending on their answer, it'll either be one or two risk factors. So now we are on substance abuse, and there is only one dynamic risk factor under the ORAS. The longest period of abstinence from alcohol was less than 6 months. So if you have a client who's been sober longer than that, but they have any of these other factors, it appears there's nothing you can do. However, again, to kind of give you an idea, I compare it to the LSCMI. Let you look at it. What you have to understand here is that the domains, criminal history is always static. The other domains are generally dynamic, but it depends on how a particular assessment writer has written their questions. They choose different ones. But that's why when you're looking at this, look at the big picture of what can I do to help my client with their alcohol drug problem or with pure associations. Those are the factors. It's kind of interesting if you look at gang membership, it's a hybrid. If you've ever been a member of a gang, it's static. But if you currently are a member of a gang, you can quit. So you can reduce it by 1 there. Next, criminal attitudes and behavior. Now, I have some notes which I will provide on criminal pride, but most of this is self-explanatory. Now, the ORAS also has a place for the probation officer to look at other areas of concern. These would match up with the specific responsivity issues. So probation officers are looking for low intelligence, reading and writing limitations, history of abuse, neglect, mental health issues, etc. Why? Because these are barriers which can prevent an offender from benefiting from interventions. Okay, that is how the ORAS is reported on the sentencing assessment report. I copied that, marked it out. That's what it looks like. They give you the risk level, and after a brief explanation, what I'm seeing is they're telling you the overall, and then they're going through each one, and they are only including the particular risk factors in domains which are medium or higher. So if your client has some domains that are low risk, they're not going to be showing up unless they decide to change things. I got this from the scoring thing online. This has been validated differently for males and females, and that's why you see a difference in the risk categories based on score. I also decided to give you some information on how the domains are scored. So if you have somebody with a 3 employment, education, financial, what you try to do is there any way you can get that down by addressing dynamic risks to a lower level. Okay. So do we have any other questions right now anybody wants to ask before I kind of go to the next part? So what we've covered so far is general R&R theory very quickly. We have covered how the RANT is used in Missouri and how the Ohio Risk Assessment System community supervision tool is being used. Are we good to go on? Okay. So I want to talk to you about developing a sentencing argument. We talked earlier about a sentencing theory, and I would say the very first thing I would do with most cases is really decide what are the chances my client's going to get probation, because that's really going to determine how strongly I'm going to be arguing risk. We want to talk about the sentencing assessment report, how you can use that information. And just to throw this out here, I'm really big when I'm representing a client. I want to find as much documentation as I can to help my client out. I'm trying to document positive information on the SAR. I'm trying to document any of their actions they've done to address criminogenic or other needs since their arrest. And I'm collecting character reference letters, a statement to the court on what they've learned, apology letters, etc. The bottom line is here is you document everything. Now, back to the sentencing argument. Is there a mandatory minimum sentence? So that's really the first question we have to ask. And if no, do the nature and circumstances of the offense mandate incarceration? If no, it's this next area which I believe is probably going to is the area for the best use of risk, needs, and responsivity theory. And that's because we know from evidence, we know from research that high risk, high need offenders do better, for example, in treatment courts than any other risk category of offender. In fact, that's what drug court's designed for. So by focusing our services in the community on high risk, high needs individuals, not only does research show we reduce their risk to reoffend, we are saving a fortune. So that's why it's important. Now, imagine a client with a lengthy criminal history and a substance use disorder, most likely have undiagnosed major mental illnesses. A prosecutor most certainly be focusing on your client's criminal history and danger to society. And criminal history is the one risk domain that is static and cannot be changed. So in order to get probation, in my opinion, you need to change the focus of the judge to those factors which can be changed. If you can identify needs and the barriers in a client's life, if you can refer them to agencies and resources to address those needs and factors, and if you can document what they do, you have the foundation of a winning argument at sentencing. You've shown that your client can be rehabilitated in the community by addressing their dynamic criminogenic needs. So next, we're going to go over a scenario. So I want you to think about this scenario. So you receive an Ohio risk assessment system results in your sentencing assessment report. They've classified your client as high risk to reoffend with the following domains are medium or above: criminal history, education, family and social support, substance abuse, peer associations, and criminal attitudes and behaviors. So my first step would be to determine which of these particular risk factors are static and which are dynamic. And I'm talking about the particular risk factors. We already know that all the factors under criminal history are static, so we'll let the prosecutor argue that. So if you go to education, employment, and financial situation, and this is spelled out in my speaker notes, but not being employed at the time of your arrest is static. You can't go back in time to the date of the arrest. But the other three, currently unemployed, make better use of time, current financial situation is poor. Those are all dynamic, changeable factors. And more importantly, those factors aren't going to be addressed in prison. Those are the factors that need to be addressed in the community. Look at family and social support. Parent with a criminal record, static. But if you're not satisfied with your relations or an unstable residence, that can be changed. You're not going to change to a stable residence sitting in prison. Substance abuse. Okay. In this situation, all of this offender's risk factors are static on the ORAS, and that's sad. However, substance abuse itself is considered a dynamic domain. So think about the LSCMI information I gave you. Look at it. Is there something there that's static that you can address? Is there some way that you can encourage them in a direction which makes it less likely they abuse substances and more likely that they are living a pro-social life? Okay. Peer associations is an outstanding example. In this situation, all four of the factors are dynamic. Now, if we send this individual to prison, is he going to make non-criminal friends? Is he going to seek out non-criminal peers? Are his activities primarily going to be pro-social or antisocial? That's, I think, how you make the argument. Now, on criminal attitude and behavior problems, I did not specify or spell out any risk factors there. There's a reason. This is one of those areas that even though all the factors are dynamic, this is what's going to be addressed on probation, most likely through a cognitive behavioral tool such as moral recognition therapy. So looking at these, I come up with a total of 24 risk factors. 14 of those risk factors are dynamic or changeable. My second step would be to look at the dynamic risk factors and ask myself which can be addressed in prison and which can only be addressed in the community. And I would create a contrast there. And in looking over the above dynamic risk factors, I don't see a single one of them being met by incarceration because of the constant exposure to criminal and antisocial companions and criminal and antisocial thinking. The offender might get some substance abuse or mental health treatment, but they can get that in the community. He or she may be able to find a job while incarcerated, but I don't see that being employment I would want to list on my resume. Incarceration will not help them stay away from criminal and antisocial companions. So if we allow the prosecutor or the court to look at public risk and safety too narrowly, we run the very real risk of increasing the risk to public safety in the future. And this is the way we do it. We paint them a picture of alternate realities. Option A, option B. Plan A, plan B. Let them see the likely outcomes based upon the probabilities, and generally the right option is pretty obvious. So, using risk need responsivity principles in your practice for better outcomes for your clients. I kind of borrowed what I said earlier, but this is for you. Assess, assign, assemble. One sec. So I could have created a simple questionnaire to give you, and I didn't, because I really believe there is a benefit if you create your own questionnaire. It took me a long time to internalize these concepts and to look at criminal cases this way by second nature. So one of the things we're going to talk about, I'm going to show you what should be included in a simple questionnaire. And really what you do is help your clients set goals in each of these risk areas and figure out the steps necessary to reach those goals. Encourage them. Document every good thing your clients do. For example, if they get treatment, education, employment, they go get family counseling, do community service, you document and provide this because it is proof that they are living a pro-social life. On the contents of a checklist, I have this actually in the speaker notes. And what I've done is I've gone over the different central 8 domains. And then after that, I have given you a list of possible responsivity factors you want to question them about. But the bottom line is you can do a lot of this stuff without an assessment. If you know what these factors are, what the domains are, you know what the particular factors are, you can have a conversation with your client. You can encourage them to change, and you can find some specific goals to give them, the steps to reach those goals that will change their lives. And if you document that, the chances are outstanding that it's going to get them a better outcome in their criminal case. My last thing I say, and I think it's the absolute truth, the best argument at sentencing and the best mitigating circumstance at sentencing is documenting proof that your client is living a pro-social and a flourishing life. The next page, we are done. The next page, I've listed some resources. There are a couple of more resources in the speaker notes. And that is that. So if we have questions, I would be more than happy to answer them or go back over any other material I previously covered.
Guys, if you do have a question, just go ahead and either raise your hand and I'll unmute you, or you're free to put anything in the chat. Souder, you did too good of a job.
Yeah, it didn't take long. Was it supposed to be an hour or was it supposed to be longer?
You're supposed to go for 4 hours. That was the plan. 4 hours.
Okay, well, I'm going to start on my next topic. I will tell you this. This is half of what I'm working on right now. I would never have done this if I hadn't gotten involved in drug court, but here's what I've seen with treatment courts.
And as you answer this, you might notice that Ross tossed you a softball that says, how conversant are the judges with this? So I think that's going to, yep.
They're getting there. Greene County, I think, is very conversant. I think the judges in the larger jurisdictions, I think what I'm seeing are, and even in the smaller jurisdictions, but this is where you educate. This is evidence-based stuff. It's like going to Las Vegas and saying, do I want to go for a 2/3 chance of losing, or do I want to go for a 2/3 chance of winning? You can't herd cats. You can't control offenders, at least willing. You can't make them want to do it. And that's what I was going to say, though, because see, that's really the second part of what I'm working on. If you'll notice, one of the responsivity issues mentioned is motivation. And all things being equal, I don't think there's anything more important. I don't care how perfect a treatment court is. I don't care how well you follow evidence-based practices. If I don't want to change, you're not going to change. And along that same line is the fact we talked earlier about well, actually, the types of motivation, intrinsic and extrinsic motivation. We didn't talk about it. I'll talk about it now. It's one of the real things that we need to take into consideration here. Treatment courts and the judicial system are based upon extrinsic motivating factors, rewards and sanctions, okay? That may change somebody's behavior in the short term, but they will never change their behavior unless the motivation is intrinsic, and that can't be forced. So I think the best thing we can do as defense attorneys is to educate our clients on risks, on needs, show them, encourage them to lead a pro-social life, show them what that looks like. I think that's a large part of it, is making an environment that is conducive to intrinsic motivation.
Excellent. Well, we are at the full hour. So if anybody has any follow-up questions, I do have to tell you from personal experience, Souder does know the answer. Feel free to give him a call or shoot him an email. I know that I've gotten responses back from him quickly in the past, and I'm sure he'll do the same for you. Additionally, we will be emailing out Souder's full presentation. There are, in the materials, you'll notice you can download a PDF right now, but I don't think that's the full presentation. Souder will have an updated, we will send out an updated one, so feel free to shoot Souder a text, or excuse me, an email, and he will get that back to you. And wait, I'm seeing something click up. Souder's email to request full presentation, and then never mind. Perfect.
Yeah, it's on the last page.
Last page. And guys, we truly appreciate you coming in and supporting MACDL and watching this. And Souder, we thank you for your time.
Hey, thank you. Appreciate it. Have a great day.
You too.